Okay, good morning, everybody. It has just gone 10 o'clock, so I'll make a start as the last few people are joining. Welcome to April. We're already a quarter of the way through the year. Hope everybody had a lovely long weekend and managed to enjoy as much as we could before getting back into it. Um, yes, so latest session of these employment HR coffee briefings that we're running. We are after today, halfway through this first cycle. This will be the sixth of these first 12, if my maths is right. And today, what I thought I would talk about, as you know, is sickness and sickness absence management. As always, for those of you who've been on these calls before, I've got a Q&A box in front of me that I can see. That stuff just comes to me. I'm the only one who can see that. There is also a chat function if you can find it. By all means, feel free to use that to engage with each other as well, share ideas and good practice. It's as much an opportunity for you to share with each other as it is for you to hear from me today. So without further ado, sickness and sickness absence. First thing I suppose to cover, is this a little bit of a familiar topic? Yes, I do acknowledge that there is quite a bit of overlap with last month's session on capability and performance. They are often intertwined, as you would expect, because of course, one of the primary causes of a capability issue will be somebody's sickness absence. And in due course, a sickness absence equally has the opportunity to become a performance-related issue, a performance-related dismissal in due course if we go that far. So what I thought I would do with today's session is, rather than focus too much on the procedure and the law and the processes and all of those things that we sort of covered in last month's session on capability, I'm instead going to do a little bit of some of my thoughts about issues that arise around sickness and sickness absence, with a smattering of legal issues rather than sort of too much of a repeat of last month. You're welcome. So moving straight on, let's sort of think about the basics then of sickness and sickness absence. Some of this data over the next few slides I've drawn from the ONS's annual labour survey. I think the last one that they was published, it's a couple of years ago now. Sickness rates in the UK currently hover at around 2.2%. What they mean by that is that on any given moment, approximately 2% of the workforce is on some form of sick leave. Obviously, sickness absence is problematic for us as employers and as businesses. On the plus side, that's not a particularly high figure, and it's hopefully one that those of you who work in or with larger businesses will potentially recognise. If you've got sort of 200 people, then that suggests that 3 or 4 may well be off sick at any given time. That's not a particularly extreme statistic, I would have thought. And as I say, this data came from the 2021 survey, or 22 talking about 21, that the ONS did. And during the course of that year, as we can see there, approximately 150 million working days lost to sickness absence. Now, 2020, 2021, funnily enough, a large number of those would have been COVID absences, as I'm sure we're all aware. So I suspect that figure has dropped a little bit now that we don't have compulsory sickness absence. But it is still a relatively high figure, and it does go to show that the primary focus of any sickness absence process, any sickness absence procedure, is almost always going to be about getting the individual back to work. And that is something that we will come on to explore sort of later in the session. So throwing this straight out to you and getting your involvement nice and early, the ONS survey did come up with the leading causes of sickness absence in the workplace. And yes, for this session, I am going to force some of you to engage. Let's have a stab at them. It's not a trick question. I'm sure you can guess. Answers on a postcard, or preferably in the chat or Q&A, please. Top 3 causes of sickness absence in 2021, 2022, 2020, 2021, not counting COVID. Anybody going to take a stab at what one or more of those may have been? As I say, it's definitely not a trick question. It's exactly the ones you're probably expecting. Yeah, we've got a few takers for stress. Anybody else? This also proves to me how many people are actually paying attention to anything I'm saying. Yeah, stress, mental health, sickness bugs. Yeah. Last few seconds just to give anybody else a chance who wants to chip in. Yeah, I'm not surprised that I'm seeing mental health and stress from a lot of you there. Okay. Yeah, there's the results. So yeah, approximately just under a third there are those minor illnesses still. That's to be expected. They're your colds, flus, and let's face it, probably hangovers as well are going to fall within that list. Second one, there, the one that didn't crop up actually, musculoskeletal problems. It still does remain one of the leading causes of sickness absence in the UK. Back, shoulder pain in particular is still there. I suspect, although I'm certainly not some kind of osteo specialist. I suspect the leading reasons for that may well be the number of us who partly spend our days hunched over a desk, and that is fundamentally not a great position for the human body to be in. And probably also a reflection of both our sedentary lifestyles and probably also the fact that we've got a slightly aging working population as well. No age discrimination there. It's simply true that musculoskeletal problems set in increasingly as you get older. And yet we got mental health there as well at the bottom. Again, this is the data that was talking about 2021. I'll be surprised if those last two haven't balanced out a little bit more in the last couple of years, because I do think that certainly post-pandemic, mental health has become a revisited topic, a revisited awareness, and also the experiences of the pandemic sort of driving people towards being more aware of the importance of sustaining your mental health and thereby having periods of absence as a result of it. So yeah, there's our leading causes of them. They're the things to be particularly aware of. What's interesting, of course, is that apart from where the musculoskeletal or the mental health potentially amount to disabilities themselves, what we're suggesting here is that major disabilities and sickness absences are not necessarily a predominant cause of absence, even though there's arguably a perception that they can be. So legally, what do we need to think about? Yes, staff are entitled to be off sick. I know I don't need to tell you that, but I did a presentation in the last couple of years to an audience that included an American audience, and their response to the question, what do you do if someone takes 5 days off, was sack them. So I know I don't need to say this to you guys, but I will put that in there because, well, it's true. Staff are entitled to be off sick. We're all ill at some point. All of us will have been ill at some point. If you haven't been, do keep away from doctors. They will be interested in your blood if you've never been ill. As we know, the individual will self-certify for the first 7 days of absence following whatever process or procedure you expect them to. And then beyond that, they are looking at medical sign-off by way of a fit note or some other form of evidence. We'll come on to fit notes in, I think, the next slide in just a little bit more detail. But I have also put on there the alternative to the fit note, the Allied Health Professional Reports. You as an employer can choose whether you will accept that or not. The fit note, what people think of as a sick note, is sort of the formal official version that we're all familiar with. Allied Health Professional Reports can be produced by medical practitioners who are perhaps not necessarily what those of us think of as the traditional people who would sign a fit note. They are perfectly valid. Legally, you can use them. They're still fine for the purposes of processing SSP and all of those sorts of things. But again, it's entirely up to you as to whether you'll accept them or whether you would prefer the actual sort of GP's fit notes in the traditional sense. There we have one. We all know what a fit note looks like. A few things to say on this, really. The first thing I suppose to pick up on here is they are a fit note. They're a fitness for work. And there's sort of two elements to that that need to be explored. And I think it's very easy for people to get wrong as to what this note actually does. The first thing it does is it tells the employee one of two things: either that they are not fit for work, or that they may be fit for work subject to potential changes to the workplace. That's all this document does. So it doesn't, for example, say that they are not fit to do other things. And this is something that occasionally crops up, particularly when I'm advising employees in this situation, and they'll say, look, I've got a fit note. I don't feel like I can do anything because the fit note says I'm not fit for work, and I've told my employer that. As I say, what it does is it says you're not fit for work. You're not medically capable of performing your professional or workplace duties, whatever they may be. It doesn't mean you can't go shopping. It doesn't mean you can't see friends. In theory, it doesn't even mean you can't go on holiday. Those things are not your day-to-day job. And the advice that I'm often giving in that situation is, yeah, look, do them. Your employer's not the DWP. This isn't a document that says I'm incapable of doing anything, including looking for work. It's simply a document that says this medical practitioner doesn't believe that you are fit for work. The other thing these documents don't do is ever say that the individual is completely fit for work. So again, this is something that crops up occasionally, and you will see an employer who will say something like, no, you need to go back and get another document from your doctor to say you are fit for work. The vast majority, those of you who've been in these situations will know GPs generally will not produce that document. Their only obligation is to produce a fit note that confirms that, in theory, the individual is not, in fact, fit for work. Other things it doesn't do. It doesn't say that the individual is not capable of engaging in a grievance process or a disciplinary procedure, for example. That is, as we'll come on to later, a decision that needs to be made by you as the employer as to whether you think it's appropriate to continue with those processes. For example, just because somebody is off sick, that doesn't mean they can't raise a grievance and expect that grievance to be dealt with. Equally, just because somebody is off sick, that doesn't automatically mean they can't engage in a disciplinary process. You may well be signed off because you've broken your leg. That doesn't actually stop you functionally engaging in answering questions, online meetings, those sorts of things. That could, in theory, still proceed. As I've said there, the other thing it does would occasionally make recommendations. The extent of those will really depend on who it comes from, if I'm honest, and how engaged the medical practitioner is in the process that they're involved in. Yes, you might just get a box that ticks amended duties, and that will not be very helpful to you at all. Something we can come on to again in a later session as to what those sorts of changes look like. So that is fit notes. Again, I'm assuming most people are pretty familiar with those anyway, so I'm not going to spend too long talking about those. Sick pay, very, very quick on this. Sick pay, yes, will either be basic statutory, will be contractual, or will potentially be non-existent, depending on the individual involved. Bear in mind that for statutory sick pay, they must be an employee. That often surprises people. They've got to actually be an employee of yours. They must be earning, I've got 1, 2, 3 a week on there. It's whatever the national interest threshold is, the minimum earnings threshold is at the appropriate time, which is due to imminently change. And as we know, it's paid from the 4th day of absence for a period of up to 28 weeks. Statutory sick pay is not the most friendly thing to be on. Anybody who, again, would have dealt with this during the pandemic in particular, when we were sort of required to go off sick occasionally, I mean, it was less than £100 a week. So for those of almost anybody, let's face it, anybody earning much more than £100 a week ordinarily is significantly worse off on sick pay. It arguably encourages a return to work. I would suggest it probably occasionally encourages a return to work that is too early. Yes, you can require evidence of the reason for somebody's sickness beyond those 4 days, whether that is self-certified or by way of a fit note before paying it. Lots of organisations will also have contractual sick pay included somewhere in their contracts or policies. Contractual sick pay can be arranged either for a set period, i.e. You get 5 days a year on full pay, and beyond that it's statutory or nothing. Or it can be some kind of sustained set rate or an overlap of the two. So a fairly common example is maybe at director level or in the public sector, 6 months at half pay and then reducing accordingly. They became very, very unpopular, as I've said there, a few years ago, because staff were starting to see them as entitlement to have a duvet day. And you'd get towards the end of a leave year or a sick year or whatever operational year you worked in, and organisations were finding that people were treating it as an entitlement and suddenly taking 4 days off sick when they very, very clearly weren't. This did lead to quite a big shift in the use of contractual sick pay a few years ago, and organisations that maybe once would have had quite generous sick pay arrangements were suddenly only sort of offering 4 or 5 days. I think there's been a little bit of a shift back on that, and I think there's become a realisation that it's better for somebody to take a shorter period of decent sick leave and then come back to sort of full functionality, rather than have them struggle to return to work in a situation where maybe they aren't quite ready to, but because they have to out of affordability. That overlaps with, as I put on there, mental health days. Again, feel free to chip in if you've got opinions, comments or experiences on these. But an increasing number of organisations are starting to offer either paid or unpaid mental health days as an opportunity for staff to simply go, you know what, I need a day out. I'm not sick as such. I've got a risk of becoming so because of stress, because of my mental health situation. And it is important to me to step back from where I am at the moment. Yeah, there is, I think, sort of this step back towards a recognition that at very least unpaid time, but certainly paid time off to recover from any kind of sickness absence, whether that be physical or mental, is important, and it is a potential benefit that staff are interested in. The obvious legal issue of contractual sick pay is the risk of a contract claim by an employee if it's not paid or if it's not paid correctly. So if you do have them in your contracts, or you're working with an employer who may have them in their contracts, do make sure you're aware of what those provisions are, exactly how they work. One of the biggest issues that people crop up with in these is the period for which they're paid. And whether it's a rolling 12-month period, any given 12-month period, a year, for example, that's where you tend to see the contract issue come up. Discretionary sick pay, obviously much more common than contractual sick pay. Simply your decision as an employer, as a business, to offer some kind of enhanced sickness payment that is above and beyond statutory minimum entitlement. You are more than entitled to do this. There is no problem with doing that and saying to so-and-so individual, you know, fine, you're off for X amount of time. We know ordinarily you'd only be getting about £100 a week sick. We're prepared to give you AN amount on top of that. No problem with that whatsoever. But two kind of big legal issues to be mindful of with it. The first one, as I've said there, the risk of that becoming a potentially contractual entitlement. Main way that would happen, I think, is by sort of the custom and practice arguments. If you are offering discretionary sick pay to every member of staff who is off, they always get it, they always expect it, and it becomes an ordinary thing that the workplace does for people on sick pay. There is a risk of it being deemed contractual and it becoming an expectation, because it appears to have become a normal part of the working relationship. Less likely to be a contract issue, but still likely to give an additional point of argument. It's where you've got one individual who is used to receiving it. It's not something that's rolled out across the business, but it's common for one individual and they expect it. Or they are on a long period of absence and it keeps going for a long time. There is an argument that they will start to expect it to have become the norm as well. And therefore, when you are doing discretionary sick pay, it's particularly important to make it clear from the start and on every review that it is discretionary, that it can be stopped at any time and they'll revert to statutory, or if they've exceeded statutory, they will be on nothing, and to review it periodically and make sure it's appropriate. The last thing any of us want is to have an individual who is on sick leave for 6, 7, 8, 9 months, and by this point you're still paying them at full pay. That's going to become unsustainable very, very quickly. There's a question that's just popped up: can discretionary sick pay supplement contractual sick pay? By which I'm assuming you mean if you've got a contractual sick arrangement for, as you say there, the 5 days that I mentioned, can you then do discretionary on top of that? Yes, you absolutely can. Get to the end of the contractual sick period, or somebody has expired, used up their 5 days, they are then off sick for some other reason, you want to keep paying them discretionary. Yes, absolutely. But as I say, make sure that it's very clear that it is a discretionary payment. The other risk of discretionary payments, it's the same risk that you have with any kind of discretionary benefit or offer made by the employer, is the risk of it being discriminatory. And that is simply the question of, why did so-and-so get it, but I didn't? And if they can highlight a potential protected characteristic behind that, there is an argument that there has been some kind of discriminatory intent, potentially even direct discrimination. Again, the best way around that is to make sure that you're very clear of your reasons for offering it to any given individual, and obviously that reason is not in and of itself discriminatory, and that you can objectively justify any decision that you've made to make discretionary payments. Okay, there's no other questions on that. So, big question that sort of comes up from that: is protecting enhanced sick pay a possible reasonable adjustment? So let's imagine we've got a situation where an employee is off on a sustained period of sickness absence, and the reason for that is their disability. Is it a reasonable adjustment? Is there an expectation on you as an employer to protect any form of enhanced pay if it arises out of a disability-related absence? So I think we've got 2 extended questions from that. So yeah, scenario 1. Employee A has a disability. Let's imagine it is something like CFS, chronic fatigue, is probably the best example we can use for this. And the reasonable adjustment that has been agreed and implemented by you as the employer is reduced hours. So instead of working 9 to 5, 5 days a week, they're now doing 10 till 3, 5 days a week, because that beginning and end of the day is the particularly problematic part for them. Here's my question. They are contracted to work 9 to 5, 5 days a week. They're actually working approximately 10 hours less than that. Do you need to protect their full pay, or do you only pay them for the hours they've worked? Open question. Please feel free to contribute. Good excuse for me to have a drink while people are thinking about that. Any other opinions on this? Yeah, I'm getting a few for only the hours worked. Anybody going to punt for protect their full pay? Yeah, no, nobody's going to go for it, are they? Okay, fine, let's move on. Yeah, so there's no specific requirement. The reduced hours in that situation is a prime example of what the HRC and various Equality Act guidance says is a good example of a reasonable adjustment, reducing someone's hours. That guidance says absolutely nothing about protecting the salary, even though strictly speaking, one could argue it's not a contract change, it's simply a reasonable adjustment. I think there is a recognition that an employer is doing what they can to assist an employee in this situation, and that the alternative would be that the individual doesn't have a job anymore. If you can't accommodate someone with a disability, they can't work for you. So I think there is a general recognition that the reduction in pay is obviously a fair consequence of a reduction in hours. But I have put a little interesting legal point on here that is untested. I'm not aware of it ever being tried in the Employment Tribunal for probably exactly the reasons I've just said, but bear with me. The reason that they have reduced their hours is in connection with a disability. Therefore, their reduced hours is something that arises from their disability. one could then argue that their reduced pay as a result of those reduced hours is a detriment resulting from something that arises from a disability. That's a Section 15 claim, discrimination arising from a disability. And therefore there is another theory as an extension of that, therefore, that if you've got a potential Section 15 claim, you would have to objectively justify the decision to reduce their pay. Now, for all the reasons I've just discussed, I do not think that would be particularly difficult to do. An employer is very likely to turn around in that situation and say, well, the objective justification is we wanted to keep you employed, but we can only afford to do so for the hours you're working. That is, I think, a perfectly reasonable justification. And you can absolutely see why that argument has never been run. I do not think it would be a very, very popular argument with the Employment Tribunal. So let's consider one that does actually have a tested result. Different employee, employee B, who is on long-term sickness due to a disability-related illness. This pulls back, in a sense, actually, to the discretionary sick pay argument we had before. They are about to exhaust their contractual entitlement to, I've used 6 weeks pay, it could be longer than that. Is it a reasonable adjustment to continue full pay throughout their disability-related absence? They have a contract that entitles them to a certain amount of contractual sick pay, but they're now beyond that and are still off for a disability-related reason. You can see again an argument here that the reason they're now losing out on their salary is disability-related. Could it be reasonable to continue to pay them even though they've exhausted their contractual entitlement? Any thoughts on that? See who's going to be brave here. Yeah, got a few interesting answers, couple of no's, couple of yeses. I've got one comment, would it be unfair on other staff on long-term sick to continue to pay them just because this individual's, just because it's a disability-related absence? Yeah, why would that be fair on the, say, non-disabled staff who are also off? That's a perfectly fair question. Yeah, again, you may need to backfill their role. So yeah, somebody is off sick, exactly the same reasons as we were just saying before. Is it fair that you're paying twice for them? So a couple of mixed answers there. In effect, I've got some yeses and I've got some nos. Let's have a look. So yes, this one has been tested. This is one that's got an employment, in fact, a Court of Appeal judgment on it that says, in theory, yes, but only in rare or extreme cases. And the leading case we've got on this is O'Hanlon and HMRC, funnily enough. It's amazing how many of these cases involve government bodies when you start digging into it. And what the Court of Appeal helpfully said here is they're sort of looking at the reason and the responsibility that sits behind what an employer is expected to do. And what they basically said is that reasonable adjustments under the Equality Act, and I think by extension we can talk about this in sort of all workplace sickness absence adjustments, is about enabling a return to work and people to access the workplace in a fully functional way. They use the phrase not to treat disabled people as objects of charity. That's not the function of an employer here, to pay somebody long term to be off sick, whatever the reason for that may be. I agree with some of the comments that have been made about it. Yes, it's potentially unfair on those staff who are not disabled. There's no obvious discrimination claim that arises from that, but there could well be some bad feeling. We've got people suggesting in the comments that it would set a precedent if you were doing this, and then suddenly everybody who's off on long-term sick expects full pay. And yes, I do think this is one of those situations where, depending on the circumstances, you may well find that discretionary sick pay is of much more value to you. A much earlier case on this, the absence was disability related, and the reason that the individual was still away from work is that the employer had failed to make reasonable adjustments, and the court extended their view on this and said, actually, in that situation, yes, you should be paying the full salary to which they're entitled because you're the one preventing the return to work. I would probably suggest that's not a reasonable adjustment argument so much as a financial loss resulting from discrimination, but that is how the court chose to word it. And therefore, we do have these situations where, in theory, there could be an expectation, but it will be an exception to the rule in only very extreme cases. So there we go. Interesting to bear in mind. Okay, let's talk about a few more sort of practical issues just for the last 20 minutes or so. We'll look at the distinction, short-term absence, long-term absence, dealing with intermittent absences, and we'll touch on occupational health towards the end of the session as well. So, short-term absence. Again, as I'm talking through these ones, do feel free to comment and chip in because a lot of these are very much organisation dependent and how you define certain aspects of your policies. You will not find any legal definition that defines the difference between short and long-term sickness absence. There is no piece of statute that says it becomes long-term absence after 6 weeks or 6 months or 6 years. And therefore, it is very much dependent on your internal policies and procedures as to when you draw this line. Generally, of course, short-term absences are not a major issue. Obviously, anybody being off sick is a nuisance because it never happens at a convenient time. But the majority of short-term absences are, as we were saying earlier, your colds, your sickness bugs, your hangovers, I was at a wedding last week and still not quite over it. They're most of your sort of day-to-day normal short-term sickness absences. And therefore, how do we deal with them? Well, we record them, we make sure the reason is documented, we pay our staff accordingly, and we get them to self-certify or fit note if it rolls over, and we just deal with it. People are off sick occasionally. People are increasingly off sick, obviously, towards the end of the year when cold and flu season starts. I've put meeting on return with a question mark, and again, that's simply because of the underlying reason, sort of, I suppose, behind what is and is not a short-term absence and how you define it. I suspect you're not going to have any kind of formal return to work if somebody's off for 3 days because they've got a cold. You may, and your policies and procedures may require you to do that. I'd suggest it's unnecessary. But of course, if your short-term absence extends to maybe 2 or 3 months and you've had somebody who is still officially under your procedures off for 6 weeks, then obviously some kind of return and reintegration process is going to be quite important to that individual if they've been off for that length of time. Persistent and intermittent absences, always a fun one. People who've had to deal with this will know how much of a nuisance this can be to manage, to address, and to deal with. And this is where those short-term absences really do start to be a problem. And this is why it's particularly important to be recording and documenting the reasons for absences, because this can go one of 2 ways. Persistent short-term absence is either going to be somebody taking the mick and having time off, which they call sick when they aren't, or it's going to be starting to indicate some other kind of issue that they've got which needs to be addressed. So dealing with the first one, any kind of persistent absence it needs to be identified for a start. And this is why not only should you be recording sickness absence, but keeping an eye on it, because eventually you are going to notice either a pattern or some kind of frequency. The pattern may well be, we notice that somebody has a week off and funnily enough, they're ill the Thursday and Friday beforehand or the Monday after they're due to be back. It may well be that your sickness absence happens to coincide with an away fixture that they've had to travel to go and see for their favourite team. Or it may well be that it coincides around things like what you know is their birthday or things like that. If it's those, you can almost certainly say that there's some kind of ongoing deliberate misuse of the absence policy here, and we'll start to look at that and explore that accordingly. If, on the other hand, what you're noticing is that periodically somebody is having 2 or 3 days off, perhaps every 6 weeks, and there's no obvious pattern around it that makes you suspicious of the actual motivation, then what you may be looking at is somebody who is struggling. They may be suffering building towards burnout. There might be some kind of stress angle going on here, or it may well be that they've got an underlying medical condition which you're not aware of at the moment, or indeed potentially that they're not aware of at the moment. So this is why I always think when you're looking at persistent short-term absences, do keep an open mind, and unless it's obviously someone swinging the lead. But in particular, keep reasons and records. If somebody is having 2 days off every 4, 5, 6 weeks because of what they're defining as stress or mental health, that's probably going to set alarm bells off more so down a we need to support this person route than if somebody is suspiciously having every Friday off when Bournemouth have an away game on the Saturday. The latter there obviously is a potential disciplinary issue. It's abuse of the sickness absence procedure. It's potentially fraud. It's actually quite a serious issue. But as I say, on the other side of this, you have got the alarm bells being set off if there is something else going on here. So the conversation is always, look, we've noticed these absences. Let's talk about them before we decide where we go with it. Fine. Touch on long-term absence. Again, no absolute definition here of what starts to amount to long-term absence, but this is where I will start to talk about the importance of policy. I'm not generally a huge let's have a policy for the sake of having a policy person, but managing absence is one of those that you absolutely should have. And that policy should set out clearly why the policy exists, what the purpose and intent is. And the purpose and intent is always to get the individual back to functional capacity so that they can participate in the workplace to some extent. None of us want to lose a potentially good member of staff who we may have invested in if there is something that we can do to assist and facilitate their return. So as I said, this is all about returning to work in a manageable way. If you initiate your sickness absence process and your starting point is we might be looking at dismissing this person, I would suggest you are starting it far too late. Your starting point is very much, they've been off for a little while now, what can we do to get them back into the office, into the workplace? Longer term sickness absence, there is going to be some increased reliance on medical evidence here. So the employee will almost certainly by now have been providing some form of medical evidence, even if that is just a fit note that is regurgitated every 3, 4, 5 weeks. You might be looking at undertaking some kind of health assessment, and that may or may not involve occupational health specialist, which we'll come on to in a moment. But I think the big thing about managing long-term absence, and again, I'm not going to focus on process and procedure here because a long-term sickness absence policy is functionally either a disciplinary or more appropriately a capability management process anyway. It's about keeping on top of it. And the last thing you want, and one of the hardest situations to deal with, is a long-term sickness absence that's either been ignored, and we're now at 4, 5, 6 months, or has been started and needlessly postponed for 4, 5, 6 months. Obviously, if it's disability related, you've got to allow for any reasonable adjustments that the individual might need to the process or procedure. That may involve delays, that may involve a slower process, but I think fundamentally the process should be continuing unless there's a very, very good reason not to. There will always be examples and exceptions. Obviously, somebody who's undergoing treatment consistently during that period obviously can't engage, but something should always be ticking over in one way or another. It shouldn't just be that that individual is sat being ignored. A few reasons for that, really. From a business point of view, you want it resolved. And from the individual's point of view, it's quite important to get resolved because there is almost nothing worse than getting a long way through this process and then the conversation is, I'd like to come back to work, but I don't know how that's viable. And suddenly nobody's got an answer and nobody's got any options. And that's where the claims arise in long-term sickness absence procedures, really. So occupational health referrals. Again, I mentioned in last month's session that somewhere on the Fretton's YouTube page is a Q&A that we did with an OH professional and barrister, and you may not be a sitting judge as well, actually, on how occupational health referrals are used in employment situations, how they're perceived by the tribunals. If you haven't seen it, it was quite a long session, but do go and have a watch, because I learned a lot even as the person just sat there asking questions that were being fed in. My view on occupational health referrals, they are beneficial. They will help you as the employer, they help the employee, because they produce potentially a lot of helpful information. Third bullet point, as I've said there, you may well be of the view that you've sat and had 2, 3, 4 conversations with the employee where both of you feel you're banging your heads against the wall because you need different things and have different expectations. And then the occupational health practitioner comes up with some idea that you had not considered previously, and it works. Or they give you a piece of information that you find useful that you can now start using towards a return to work, or if the individual then, for example, does not engage with it, a potential capability dismissal. Occupational health, as I've said at the bottom, they're also great for preventative advice, and I'll come on to sort of some tips and points around that in a moment. But actually, I always find them quite a useful exercise, and I think where I generally give this advice the other way around is when I'm talking to an employee and they'll say something like, my employer wants me to go to an OH referral. I don't want to, do I have to? And actually my advice is generally, well, why not? You know, you may well think you know everything already about your condition. The OH specialist may come up with something you don't already know. It might be useful information to you. It might help. And of course, from the employee's point of view, they can go, have the referral, get the report, have the conversation, get all the information, and then, unfortunately for us, refuse to share the report with the employer anyway, if they don't like the outcome. So to an employee, I'm often saying that there's no obvious reason not to do it. So, conscious of time, getting the most out of an occupational health referral, I have hijacked some of these from that session I was just talking about that's online somewhere. If you are going to make use of an occupational health provider, make sure it's the right one. Research what you need, who you need. You know, you wouldn't come for employment and HR advice from a property lawyer. Similarly, people do specialise within occupational health, just as they do in every other medical area. You will get people who specialise in musculoskeletal issues. You will get people who specialise in mental health issues. If you need a specialist, if you need someone with a particular area of expertise because it's a, I don't know, a particularly rare condition or a particularly complicated condition, make sure you find that individual, because they are out there and they will help more than getting generic advice back. Number 2, know why you're doing it. Know what you want, what you're expecting to get out of the occupational health referral, and ask the right questions. They can be really specific questions. You know, if somebody is in a job role where you need them to do ABC, there is nothing wrong with describing ABC in quite a lot of detail to the OH referrer, on the OH referral form, and then asking the very specific question about the extent to which an individual may be able to do these tasks. Absolutely fine. The more information you can give the OH provider, the more useful the report will be to you. The number of referrals that go in and they just say, so-and-so has got a bad back, are they disabled, can they work? Well, you know, the answer you're going to get back is, yes, they're probably disabled, or no, they're probably not, and based on what they're telling me, they seem okay to work, but might need some help. That doesn't inform your process moving forwards. I've talked about obtaining consent there, very important. You're obviously sharing medical information with people. You don't want to be relying on data protection or GDPR sort of defenses or get out. Get the express consent. Speak early to the employee about this process. Do it once you know a potential issue is there, and be very transparent with them about why you're doing it. So I had a case quite recently that went to the Employment Tribunal where fundamentally the allegation was that a referral to occupational health was a form of age harassment, and that was sort of the basis of the claim. And it was simply their view that we had sent this individual for an occupational health referral because they were in their 80s, and it couldn't be further from the truth. I know the client well enough to know that that wouldn't be true at all. And what really kind of helped us in driving all the way through the defence of this claim was being very clear as to what our actual reasons were for the referral. And the very, very consistent message that had been coming across was actually, no, we just wanted to be informed because, yes, okay, we accept it is an elderly individual. We'd have sent a younger person as well. They have mentioned a potential physical condition that might impact on their work. And we just want to know what we might need to do moving forwards. And that was pretty much our defence all the way through. We never actioned it. We never dismissed this individual. There was never anything that there's no capability process started as a result. It was purely for information purposes. And when the judge starts reading your pleadings back as part of their judgment, you've done quite well. And it was simply the case that was our reason for it, and there's nothing wrong with that. The whole purpose of an occupational health referral is to be informed as to what you may or may not need to do for this individual. So that brings me briefly just to sort of start wrapping up on medical evidence and the tribunal generally. Don't forget that whether something is or is not a disability is a legal test. It's a judicial decision. When you get an occupational health response which asks the question, is this person disabled for the purposes of the Equality Act, they will give an opinion, and they will caveat that opinion by saying, ultimately, this is a legal question. It absolutely is. There's a set of criteria in the Equality Act that a judge has to follow and decide one way or the other. From your point of view and how employers deal with medical evidence, these 2 points sort of cut both ways. Nobody expects you to be a medical expert and understand everything that you have in front of you, but equally you are expected to make a decision on the information that you have available. And you can see how that cuts both ways. If an employee is refusing to give their more detailed medical information, is refusing to engage in a process, you can only make a decision based on the information that you've got. And that information may well be, well, the employee alleges they've got AN condition. We haven't got proof of that. All we know is that they've been absent for a long time and clearly can't do their job. Obviously, the flip side of that is the more information you have in front of you, the more informed a decision you can make, the safer you will be. And to be honest, the more information you have, the more likely you are to be able to make a sensible decision, which is why I do think obtaining medical information as part of a long-term sickness absence process is helpful and useful. As I said there, you're rarely a doctor. You're not expected to understand everything that can or may help. But ultimately, don't forget, whether you approach this as a disciplinary issue or a capability issue, the question is fundamentally the same. The obligation on the employer is always to behave in a reasonable manner. And if that means obtaining what you can within reason and within a reasonable amount of time and within a reasonable cost, do so. It can only help inform your decision and ultimately really will help you defend if this situation does lead to a legal claim. So just a very quick summary to finish off. Yes, whether you approach this as conduct because it's problematic, short intermittent periods of absence, or whether it's a capability dismissal because it's becoming clear the individual can no longer do their job, you may well be going down a dismissal route, so therefore you've got a risk of an unfair dismissal. As I've just said, the obligation on you is to act reasonably, as a reasonable employer would in those circumstances, and therefore to act accordingly in your decision-making process. Do be mindful of discrimination. Sickness absence, obviously there is a disability risk, the age risk, as I used in sort of my example when dealing with occupational health and periods of sickness. And I've put sex on there as well. That is just to highlight the current contemporary issue with the menopause and sickness-related absence caused by menopause, and the fact that the tribunals are happy to treat the menopause as a sex issue at present. The other one I did touch on briefly earlier, data protection and privacy issues, whether you are going externally for OH or whether this is being dealt with internally by managers, HR, whatever the case may be, please do bear in mind that you're dealing with the most sensitive information really that somebody can share with you, their medical data. Make sure your storage, retention, sharing and use of that are all proportionate, are all necessary, and that only people who are needing to see it do so. I have a question about the Bradford factor for short-term absence. I have never ever been a fan of any mechanism and this is just my personal opinion, not necessarily my legal one, but it's sort of a legally informed personal one. I'm not a fan of anything that kind of goes, here is a red line, thou shalt not cross kind of thing. Simple reason for that, yes, I think it carries a huge risk of unfairness, and I do think it carries a significant risk of a discrimination claim where it's overzealously implemented. The reason these fell out of popularity between about 2012 and maybe 5 or 6 years ago, where they started to creep back in again, is because of those Section 15 claims where it's potentially a disability. Overzealous enforcement of something like Bradford as a PCP, going back to previous discussions, can give rise to a Section 15 claim, and it's quite hard to justify an arbitrary numerical figure as a way of assessing absence, particularly where it may be connected to a disability. Beyond that, with those as well, I do also think there's a general risk of unfairness. Staff don't like it. And yes, it doesn't account for any individual circumstances, even where they maybe aren't disability issues. Anybody disagrees with me, feel free to chip in. Question there, can you pay full pay for sickness absence minus SSP? What you do is you say that anything that's paid for sickness absence includes SSP, is the easier way to think about it. Obviously, the absolute minimum will be SSP if they're entitled to it. Any other questions, thoughts, comments, or otherwise? Nope. Right, I'll just very, very slowly then point out. Next session, I believe, is scheduled for Wednesday, the 1st of May. We will go back to sort of process procedure, but hopefully the more interesting topics of conduct, misconduct, and disciplinary issues. Unless anybody's got anything else for me, I am more than happy to now release you early. Please enjoy the rest of your day and have a good April, everyone. I'll see you in May.